thank you. So, my name is Nessa, and I was born and raised in the UK. I moved to Malaysia 3 years ago and I bought land. However, there was a mistake of law with the agreement. Yet the seller told me that it was still legally enforceable. After consulting with my UK friend, she said that there is no difference between the mistake of fact and the mistake of law, and both will render the contract void. Thus, I'm making this appointment with you to inquire on whether what is the applicable rules of misrepresentation in Malaysia.
Can I have a look?
Yes, please.
Ms. Nessa, you have to understand, although common law is widely incorporated in the Malaysian Contract Act 1950, however, there are some major differences between the misrepresentation law in English law as well as Malaysian law. Ms. Nessa, in fact, in your situation, it's a bit similar to Clanport Benson and Lincoln City Council, which is a case happened in year 1998 in UK. But in fact in Malaysia, there's no case law that follow this decision. So in Malaysia, a representation still remains as a statement of facts rather than a statement of law.
Oh no! I'm so confused with the English and Malaysian law on misrepresentation.
It's okay. No worries, I will explain it to you later. So what exactly is misrepresentation? Misrepresentation is one of the vitiating factors that can turn a contract to be voidable. In order to make a misrepresentation actionable, there are 3 requirements that need to suffice. First, it must be an untrue statement. Secondly, it must be a statement of fact, not just an opinion. And thirdly, the innocent party must be induced into the contract. Firstly, when a statement is made by one party during negotiation is considered as a promise, then it will become a term of the contract. Failure in fulfilling this promise will amount to the breach of contract, whereas a misrepresentation induces entry of the contract. Therefore, it cannot be regarded as a term of the contract. For example, in the case of Oscar Chess Limited and Williams, the defendant sold a Morris car to the claimant for £290. The defendant indicated that the car was first registered in the year of 1948. Some 8 months later, the claimant became aware that the car was first registered in year 1939 and it only worth £175. However, in this case, the defendant honestly believed that the statement that he indicated earlier is the truth. Therefore, the court held that it can only amount to an innocent misrepresentation rather than breach of the terms of the contract. As mentioned, an opinion cannot be classified as a representation. For example, the statement, "I think you are beautiful," is not true or false. It is merely a belief based on other than verifiable fact. In addition, mere path can never be treated as facts. For further illustration, let's take a look in the case of DeMont and Hallett. Hallett won a bid at an auction for a piece of land, only to later discover that it was not very fertile and improbable, as described at the sales particulars. Therefore, he sued on the grounds of misrepresentation. However, the court held that the description was a mere flourishing description, and Hallett should not have taken it as a positive representation of fact. Generally, representation of future intention cannot be regarded as fact. This is because a representation that something will be done in the future cannot either be true or false at the moment it is made. However, a promise to do something in the future can amount to representation of present fact, but the intention was never actually held by the representative. This can be seen in the Malaysian case Lockview and Port Swettenham Rubber Limited Company. The respondent purchased a land from the owner whose name Yusof. Appellant was part owner of the land but was not registered. So Yusof only agreed to transfer the land to respondent when given an assurance that the respondent would not disturb the appellant's possessions of the land. Thus, the respondent brought a document stated, "As regard to Lockview, which is the appellant, interest, I shall have my own arrangement. Later, both parties entered into a contract, and an action was later taken to eject the appellant. The court held that although it was a statement of intention, but it was also a statement as to the present intention as well as the undertaking with regard to the future. Lastly, representation can be made by conduct too. It was mentioned in the judgment of Waters and Morgan that a nod or a wink or a shake of the head or a smile from the vendor intended to influence the purchaser to believe the existence of non-existent fact, which might influence the price of the subject to be sold, can amount to misrepresentation. So now I will pass my time to my colleague in further elaborating the third element in constituting misrepresentation.
First, it will be discussed on the similarities between misrepresentation in English law and misrepresentation in Malaysian law. Both jurisdictions recognize the three types of misrepresentations. The current position of English common law recognizes three types of misrepresentations, which are fraudulent misrepresentation, negligent misrepresentation, and innocent misrepresentation. The development of the area of the law is evidenced by the case of Hadleyburn and Heller. Before Hadleyburn and Heller, there are only two categories of misrepresentations, which are fraudulent misrepresentation and non-fraudulent misrepresentation. Both categories gave innocent party the option to rescind the contract. Non-fraudulent misrepresentation included what is now called negligent misrepresentation and innocent misrepresentation, but was collectively called innocent misrepresentation. Furthermore, only fraudulent misrepresentation gave the innocent party the additional right to bring an action in the thought of deceit for damages. Although the terms of fraudulent misrepresentation, negligent misrepresentation, or innocent misrepresentation are not used in Malaysia Contracts Act 1950, Section 17 and 18 covered all three types of misrepresentations known to English law as treated by Malaysian courts. This is affirmed by Judge of the Court of Appeal Gopal Sriram in Abdul Razak bin Dato Abu Sama and Shah Alam, which held that misrepresentations are of three types, depending upon the state of mind of the maker. This state of mind may be fraudulent, negligent, or innocent, in the sense that it is truly free of any blameworthiness or inadvertence. English common law's fraudulent misrepresentation is similar with fraud under Section 17 of Contracts Act 1950. Section 17, subsection A, subsection B, and subsection C cover the elements established under English common law in Dairy and Pig. Therefore, fraud is proof when false representation has been made, knowingly or without belief or truth, or recklessly careless whether it be true or false. Decision in English case Dairy and Pig was referred to in Malaysian case Double Acre Sendram Berhad and Kira Setia Sendram Berhad.
Now it's my turn, and I will further explain to you about misrepresentation, particularly the general effects of fraudulent misrepresentation.
Excuse me, Miss. What
Yes.
are the general effects of fraudulent misrepresentations?
Basically, once misrepresentation has been established within a contract, there are two principal remedies available under the English law. The first being rescission. This basically means setting aside a contract, and this can look like two things. Firstly, a contractual remedy. This means that the innocent party can set aside the contract for all purposes. Secondly, it can also look like a restitutionary remedy. This means that the claimant can recover any unjust enrichment obtained by the defendant, and also the claimant has to provide restitution for any benefit obtained at the expense of the defendant.
Excuse me, Miss.
Yeah.
What is the aim of rescission in misrepresentations?
Basically, the remedy of rescission in misrepresentation aims to do two things. firstly, to restore the parties as far as possible in the position they were in prior to entering into the contract, and secondly, to ensure that the claimant is not unjustly enriched at the defendant's expense.
Does this mean rescission automatically occurs when a misrepresentation is made?
No. When a misrepresentation is made, the contract is first voidable at the option of the innocent party. This means that the innocent party can choose whether or not they want to affirm or rescind the contract. Do you have any more questions, miss?
What about the effect of fraudulent misrepresentation under Malaysian law?
Oh, under Malaysian law, the remedy of rescission is governed by Section 19, subsection 1 of the Malaysian Contracts Act 1950. Here it states that when consent to an agreement is obtained by fraud or misrepresentation, then the innocent party also has the option of setting aside the contract or affirming the contract, hence rescission or affirmation, similar to the English law as well.
So, Miss, what exactly happened when a contract is rescinded under Malaysian law?
When a contract is rescinded under Malaysian law, Section 65 and Section 66 comes into effect. Section 65 of the Malaysian Contracts Act basically provides for the restoration of benefit, and Section 66 states that any advantage received under a contract or an agreement must be restored or compensated for. As you can see, this is similar to what the English law on rescission aims to protect as well. However, in the Indian case of Mithulai Nayak and Life Insurance Corporation of India, the Indian Supreme Court held that an individual who has committed fraud is not entitled to recover any money in an action for money had or received under Section 64 of the Indian Contract Act. This is equivalent to Section 65 of the Malaysian Contracts Act as well. The second effect of fraudulent misrepresentation is the recovery of damages. Whoa, not that kind of damages. This is in the form of monetary compensation. Yeah, so this is available in the tort of deceit. It aims to put the party back in the position they would have been in had the tort not been committed. Hence, it protects the reliance interest of the claimant. The defendant is also liable for all damages directly flowing from the fraudulent inducement. A case that illustrates the recovery of damages for fraudulent misrepresentation is the case of Doyle and Olby. Here, the claimant purchased a business from the defendant as a result of several fraudulent misrepresentations regarding the profitability of the business and the operation of the business itself. As a result of entering into the contract, the claimant suffered a loss of £5,500, but the court only awarded damages of £1,500. Therefore, the claimant appealed on the assessment of damages. Based on the appeal, the court held that contractual damages cannot be awarded for misrepresentation. This is because a representation is not a term of a contract. When it comes to fraudulent misrepresentation, damages should therefore be awarded based on the tort of deceit.
In continuation to what Proshana said, what is the rationale behind protecting reliance interest rather than expectation interest? The rationale behind employing the reliance measures of damages is that a representative does not promise anything. He merely asserts the truth of a statement and invites reliance upon it. Hence, the reliance measure encompasses the loss of profit which the claimant would have obtained from entering into some other transaction if the misrepresentation had not been made. In the case of Yam Seng Peng and International Trade Corporation, where the parties had contracted for the international distribution of sand using the Manchester United brand, and the defendant knowingly concealed information regarding important pricing information, with a crucial distribution channel in Singapore. The claimant's damages claim for false information here was justified. The Malaysian position on damages is resembled in Section 19, subsection 2, where concern is caused by fraud or misrepresentation and the innocent party insists that the contract be performed, he shall be put in the position as if the representations made have been true. In the case of Abdul Razak bin Dato' Abu Samah and Shah Alam, the Court of Appeal found that there had been fraudulent misrepresentation on the part of the defendant which induced the claimant to enter into a sale and purchase agreement. The court held that damages should be assessed by placing the innocent party in the position had he not relied on the fraudulent inducement. This would include all expenditure reasonably and properly incurred and directly flowing from the fraudulent misrepresentation, whether before or after the date of rescission. This is similar to the English law.
Hi, I will now elaborate on the element of inducement in misrepresentation. In both English and Malaysian contracts law, inducement is an essential element for an actionable misrepresentation to be formed. The party must have relied on the misrepresentation, and in order to prove reliance, the innocent party has to show that firstly, they are aware of the existence of the misrepresentation, and secondly, that they are materially affected by it, such that they are induced to enter into a contract. For example, in Atwood and Small, the plaintiff sought help from the expert to check the representation made by the defendant before entering into a contract. After that, the plaintiff sought to rescind the contract on grounds of fraudulent misrepresentation. However, the House of Lords held that, given that the plaintiff does not rely on the misrepresentation, but rather his own inquiries, there was no causal link between the misrepresentation and the contract, and hence the claim failed. Misrepresentation has to be an inducement to entry into the contract. In the case of Edgington and Fitzmaurice, the plaintiff was induced into a contract by two factors. Firstly, the misrepresentation made by the defendant, and secondly, his own mistaken belief. The Court of Appeal held that the misrepresentation need not to be the only inducement. Such was the position of common law in relation to inducement. Inducement is also a requirement under the Misrepresentation Act of 1967. Section 2(1) provides that generally, damages are recoverable when a person has entered into a contract after a misrepresentation has been made to him by another party. Similarly, Malaysian law also requires that there must be a causal relationship in which the misrepresentation has induced the party into the contract, and this is provided under the explanation to Section 19 of the Malaysian Contracts Act of 1950, where the section reads, "A misrepresentation which did not cause the consent to a contract of the party to whom the misrepresentation has been made does not render a contract voidable." In both English and Malaysian contracts law, there is no general duty of disclosure at or before the time of making a contract. This principle has been recognized in the English case of Bradford Third Equitable Benefit Building Society and Borders, where the court held that mere silence, however morally wrong, will not amount to an action of deceit. The similar stance has been taken in the Malaysian law, where Section 17 of Malaysian Contracts Act 1950 requires active steps to be taken by a party to constitute an act of fraud. This has been further reflected by the explanation to Section 17, which has been applied in the Federal Court case of Lau Hee Tia and Hargill Engineering Sendirian Berhad and another. In this case, the Federal Court held that there is no active duty on the part of the defendant to disclose to the plaintiff on the year where the machine is manufactured or that it had been previously involved in an accident. However, it is important to note that under certain circumstances, the defendant may have a duty to disclose. For example, when there is a change in circumstances. And this is illustrated in the case of Spice Girls Limited and Aprilia World Service, where the court held that failure of the Spice Girls to disclose the declared intention of one of the members of leaving the group amounts to misrepresentation. Similarly, in Malaysian law, even though there is no explicit mention of such duty in the Contracts Act 1950, Section 18B seems to suggest that there is a duty of the maker to disclose the change in circumstances, because otherwise it would give him an advantage by misleading the other party to his prejudice, which would then amount to misrepresentation.
For English law, rescission is available for all types of misrepresentations. Misrepresentations can render all contracts voidable. Therefore, the innocent party can choose either to rescind or to affirm the contract. Well, for Malaysian law, as mentioned by Prashna earlier, according to Section 19 of the Contracts Act 1950, which has stated that when the consent to an agreement is caused by fraud, coercion, or misrepresentations, the agreement is a contract voidable at the option of the party whose consent was so caused. Some limits to the right to rescind have been applied in both English law and Malaysian law. The right to rescind may be lost by affirmation of the contract by the claimant after he discovered the truth, by the intervention of innocent third-party rights where the third party acted in good faith and gave consideration, or by lapse of time. On top of that, if restitution in integram is not possible, rescission will not be allowed. Therefore, rescission and bars to rescission can be considered as one of the similarities between English law and Malaysian law.
Next, I'm going to discuss the difference of English law and Malaysian law towards the concept of misrepresentation. In English law, there is no duty to discover the truth of a representation with ordinary diligence. However, there are two situations which are applicable in the context of Malaysia jurisdiction. For English law, we can refer to the case Redgrave and Hart. In this case, Redgrave was an elderly solicitor due to retire. He placed an advertisement in Law Times seeking a successor to his legal practice and house. At a meeting, Redgrave stated that the business brought in about £300 annually. During the negotiation, Redgrave provided information that business brought in about £200 a year. However, Hart did not fully investigate the information provided and believed that the difference was due to other business. However, Hart later found that the practice to be quite worthless and sought rescission. The Federal Court held that there was misrepresentation. Furthermore, the respondent had the facilities to ascertain the position of the land, and they had sufficient time to do so before signing the contract, but they did not. Hence, the contract was not voidable for misrepresentation. The Court of Appeal held that H was entitled to rescind the contract and the return of deposit. H was not under a duty of diligence to discover the truth of R. Smith's statement. From this case, it was submitted that if a man is induced to enter into a contract by false representation, it is not a sufficient answer for him to say, if you had used due diligence, you would have discovered that the report was untrue. You had the means afforded you discovering its falsity. However, you did not choose to avail yourself of. Furthermore, the effect of misrepresentation is not got rid of on the ground that the person to whom it was made has been guilty of negligence. Next, we can refer to the case Norton and Lord Ashburton. In this case, the defendant, a solicitor, had persuaded his client to release a charge, thus advancing his own subsequent charge on the same property. It was established from this case that in fraudulent misrepresentation, no one is entitled to make a statement which on the face of it conveys a false impression and then excuse himself on the grounds that the person that he had made had available the means of correction. In contrast, in Malaysian law, there is exception to Section 19. Duty to discover the truth of a representation by exercising ordinary diligence, which can be applied under two situations. Firstly, fraud by silence under Section 17. But remember, this does not apply to other types of fraud. Secondly, misrepresentation under Section 18. Regarding to the first situation, fraud by silence, we can refer to the case Weber and Brown. In this case, Brown sought for rescission on ground of fraud when he discovered the number of trees on estate was fewer than what Weber had stated earlier. Weber tried to rely on exception to Section 19 to resist the claim and argued that B could have easily counted the trees for himself. The court held that the rescission was allowed because Weber's conduct did amount to fraud within meaning of Section 17. However, the exception in Section 19 did not apply to cases where the misrepresentation is by a false and fraudulent assertion. Therefore, the contract was voidable. Whereas, for the second situation, misrepresentation under Section 18, we can refer to the case Tan Chi Choi and others, and Eastern Mining and Metals Limited Company. In this case, there was misrepresentation by TCC's agent to a zoologist employed by the respondent that the land inspected by both parties was included in the prospecting permit, when in fact it did not. Thus, the respondent sought to rescind the contract.
Promise is not misrepresentation. The false statement which is not fulfilled amounts to a breach of contract. Consequently, the innocent party remedy lies in damages for breach of contract, not rescission. On the other hand, a misrepresentation induces entry into contract but does not become a term of the contract. Therefore, the innocent party primary remedy is rescission, not damages for breach of contract. The Court of Appeal has currently, in the case of Salt and Stratton Specialists Limited, considered Section 1 of the Misrepresentation Act 1969 is now possible for the court to order rescission even in cases where the misrepresentation has become a term of the contract. Mr. Salt purchased a luxury car from the defendant car dealer. The car was sold as brand new, but numerous defects began to emerge soon after the purchase. Mr. Salt repaired the defect, but finally lost his patience after 1 year and sought to return the car. After commencing proceedings, he learned that the car was in fact 2 years old and had been involved in a collision. Mr. Salt amended the particulars of claim to ask the court for rescission based on misrepresentation and succeeded. In cases of innocent misrepresentation, the traditional common rule was that damages were not available. Innocent is not a tort, and therefore the only remedy for innocent misrepresentation was rescission and an indemnity. According to Misrepresentation Act 1967, Section 2 Sub 2 gives the court a discretion to award damages in lieu of rescission. In this respect, the court must consider that it will be equitable to do so, having regard to the nature of the misrepresentation and the loss that would be caused by it if the contract were upheld, as well as the loss that rescission would cause to the other party. In Zanzibar and British Aerospace, it shows that the discretionary power to award damages is an alternative to rescission. On the contrary, in the case of an innocent misrepresentation, Malaysia is the same as that of England before the passing of the Misrepresentation Act 1967. Realty Sendirian Berhad and Tay Kim Dar and T. Kim The court stated that a representee who has been induced by an innocent representation may sue for rescission and consequent restitution, but he may not recover damages. Therefore, in Malaysia, innocent misrepresentation entitles representee to merely rescission and, in some cases, to an indemnity, but not to damages.
Ms. Nessa, I hope you have understand the similarities and differences of misrepresentation in English law and Malaysian law. To conclude, please take a look at this video.